Straight ahead on Law and Crime Daily, Derek Chauvin chooses not to testify in his own defense.
I will invoke my Fifth Amendment privilege today.
We break down competing expert testimony about what caused the death of George Floyd as both sides rest their cases.
If he even hints that there are test results that the jury has not heard about, it's going to be a mistrial.
And the family of Daunte Wright speaking out after the police officer charged with manslaughter for shooting him to death is released from jail on bond.
The justice would bring our son home to us, knocking on the door with his big smile.
Plus, two suspects in the disappearance of a California college student decades ago appear in court. Why the prosecutors say KRISTIN Smart was killed during an attempted rape.
We certainly believe that Mr. Floyd's dorm room was a crime scene.
Law and Crime Daily, covering court cases from coast to coast. And welcome to Law and Crime Daily. I'm Brian Ross in our studios in New York with Brian Buckmire on assignment in Minneapolis for the trial of Derek Chauvin and our co-host Terri Austin. Both sides have rested in the trial of the former Minneapolis police officer charged in the death of George Floyd. Testimony ended without hearing from the defendant himself. Brian Buckmire is here with more on that. Brian?
Yeah, Brian Ross, we saw a conversation between Eric Nelson and Derek Chauvin for the very first time, where he was given a mic and the ability to take off his mask as Eric Nelson walked through the Fifth Amendment, that the right is his and his alone, that no one was threatening him or pressuring him to testify or not to testify. And for a slight moment, we saw a little bit of Derek Chauvin's personality when Eric Nelson said that they've been going back and forth for quite some time, even up until Wednesday night, and that they finally decided for Derek Chauvin not to testify. And you saw a bit of a smirk from Derek Chauvin in reference to going back and forth so many times. Here's Eric Nelson asking Derek Chauvin those very important questions.
Whether you intend to testify or whether you intend to invoke your Fifth Amendment privilege.
I will invoke my Fifth Amendment privilege today.
Is this your decision not to testify?
It is, Your Honor.
All right. Do you have any questions about your right to remain silent or to testify on your own behalf?
Not at this time, I don't.
All right. Has anyone promised anything or threatened you in any way to keep you from testifying?
No promises or threats, Your Honor.
Do you feel that your decision not to testify is a voluntary one on your behalf?
Yes, it is.
So, Brian, as a public defender, do you think this was the right call by Derek Chauvin?
I think this is the right call for a number of reasons. First, if I'm defending this case is about the burden of proof, whether or not the prosecution has proven each and every element beyond a reasonable doubt. Second, there are some questions that I don't think Derek Chauvin can answer. Why did you leave your knee on George Floyd's neck so long? When was the use of force inappropriate and at which time? Why were you there and so fearful of the crowd? There are some things I think are going to be hard for him to answer, but of course the fear also is that cross-examination. He can, what we call, open the door by talking about his peacefulness, his knowledge about medical care, whether it be CPR after the fact or that someone can die from a knee to the neck. And those answers as to his peacefulness or truthfulness can open up, for example, the tax case that he's got going on or other uses of force that are questionable in his past.
All right, thanks, Brian. And with that decision, the defense rested, and an argument over testimony from a prosecution rebuttal witness began with threats of a mistrial. Law and Crime's Angenette Levy is here to tell us all about that. Angenette?
Brian, all of this had to do with carbon monoxide gas. That is an odorless and colorless gas that can kill you. And the questions were really about whether or not that was in George Floyd's blood and contributed to his death.
If he even hints that there are test results that the jury has not heard about, it's going to be a mistrial.
A stern warning from Judge Cahill to prosecutors after they announced they plan to call breathing expert Dr. Martin Tobin back to the stand to rebut claims from a defense expert that said carbon monoxide from a police cruiser exhaust system could have killed George Floyd.
Dr. Fowler was pretty clear. He was not saying that this was the cause of death. He's simply opining that it wasn't considered by the state. And apparently it was considered to be a ridiculous concept by the state of Minnesota that they didn't think to test it.
Dr. David Fowler told jurors Floyd's carbon monoxide levels should have been tested. Now, prosecutors say they have those test results.
It was discovered yesterday by Dr. Baker.
Special Prosecutor Jerry Blackwell said Baker reached out to them after hearing Fowler's testimony. Judge Cahill called the late disclosure prejudicial to the defense.
It's just by serendipity that Dr. Baker calls the state and says, oh, by the way, it does exist. It should be in there. It seems to me very odd. I'm not claiming any bad faith on the state's part.
Cahill allowed Dr. Tobin to return to the stand to testify about test results the jury had actually seen.
If the hemoglobin is saturated at 98%, it tells you all there was for everything else is 2%, and so the maximum amount of carbon monoxide would be 2%.
Tobin says 2% would be in the normal range.
Dr. Tobin is really considered one of the state's star medical witnesses. He had previously testified that pressure on George Floyd's neck from Derek Chauvin's knee cut off his airway and therefore cut off the circulation of oxygen to Floyd's brain, causing his death. Now, the defense expert, meanwhile, testified that, and that was Dr. Fowler, that the knee did not cause Floyd's death. Brian?
Angenette, Dr. Tobin was the last witness the jury heard before and be sent home. That's just what the prosecutors wanted, right?
Oh, I think it's exactly what they wanted. They were probably just itching and looking for a reason to put him back up on the stand. The jurors, from all of the reports we had been given from inside the courtroom, really seemed engaged. He's very charming. He has the accent. He's considered, the foremost authority on pulmonology. He's an expert on breathing. He wrote what they called the Bible on that. So anytime you can end your case with somebody like that, it's considered a plus.
And Terri Austin, in the battle of the experts we saw in this trial, who do you think came out on top?
There is no question that all of the experts, as far as the prosecution is concerned, came out on top. We saw that the use of force expert for the defense was cross-examined, and he did not hold up on cross-examination. He basically admitted everything the prosecution wanted him to admit. And we just saw in the clip with Dr. Fowler and Dr. Tobin that Dr. Tobin came out on top with common sense. He said for a fact, if the carboxyhemoglobin measured, 2%, that means the fact that if all of the oxygen is measuring 98, 2% is the most it could be. It can't be 10 to 18, and that's what Fowler said. He also said that Fowler mentioned all the studies that he couldn't find. There are at least 20 studies that there were for this very issue, showing that pressure on the back is going to narrow the hypopharynx. So I think at the end of the day, the prosecution brought on much better witnesses for their expertise for both the cause of death and for both the use of force.
And Brian, from your experience in court with all these experts, how does the jury make sense of who they want to believe?
So it kind of came up when Judge Cahill said to Eric Nelson that he was not going to give a directed verdict, that the jury can credit one witness over the other, even if it's the same side. So they can look at Dr. Tobin and say, okay, he said something a little bit different than the other doctors, but I'm going to credit him the most, and therefore I'm going to reach a conclusion based on his testimony. They can literally cherry pick which ones they want to believe and not believe, even if it's only from one side rather than the other.
All right, thank you very much. Still ahead on Law and Crime Daily, the suspect charged in the disappearance of a California college student, now under investigation for other alleged sexual assaults. But first, Daunte Wright's family demanding justice, asking how the officer who shot him could have mistaken her service pistol for a taser. The police officer charged in the death of Daunte Wright is no longer in jail. She was released on a $100,000 bond, angering the family. Law and Crime's Kim Johnson is here with more on that. Kim?
Hi, Brian. Yeah, just as the community here in Minneapolis was hoping for some closure now that the Derek Chauvin trial is coming to an end, a new case is just beginning. Kim Potter, the former Brooklyn Center police officer who shot and killed Daunte Wright over the weekend, made her first court appearance Thursday. She allegedly mistakenly used her gun instead of a taser to subdue Wright, who resisted police as they tried to arrest him during a traffic stop. Now, Wright's family, along with their attorney Ben Crump, held an emotional press conference at a nearby church calling for justice. Here is a 20-year-old's dad, Aubrey Wright, speaking about his son's death. Take a listen.
My son was very much loved. We loved him a lot. And the way he was killed, he did not deserve that. So I just wanted to say that. I felt like I had to just tell you guys what's going on is unfair. These young black men being killed. Can you blame my son or anyone else from being scared of the police? We teaching our kids how to act around police.
The former officer has been charged with second-degree manslaughter, a charge not strict enough, according to Attorney Crump, who compared this shooting to Muhammad Noor, the black former Minneapolis police officer who accidentally shot and killed a white woman. He was charged and convicted of third-degree murder and sentenced to 12 years. Now, if Potter, a white woman, is convicted of second-degree manslaughter, she faces a lighter sentence as short as 4 years behind bars. Now, the Wright family is hoping the charges will be amended. They want a stricter punishment because they call this act deliberate, not an accident. Brian.
So, Kim, what's next in the case here?
Well, this was just an initial court appearance. It was very quick, a 5-minute appearance over Zoom, just to confirm some basic information as well as identify who her attorney is, which is Earl Gray. They also set her next court appearance for May 17th. That court appearance is supposed to be in person. Brian.
Thanks, Kim. And Terry, as Kim was saying, even though the former officer is now charged with manslaughter, those charges could be upgraded at some point, couldn't they?
Absolutely, Brian. Right now, the manslaughter is second-degree manslaughter, which means, culpable negligence, the fact that she created an unreasonable risk. But if the prosecution finds that there's more evidence, she really could get more than that. She could obviously be charged with third-degree murder, and we saw that charge being reinstated here in the George Floyd, Derek Chauvin trial. And that could happen here, and that means that she is acting without regard to human life. So the maximum could go from 10 years to 25 years if, in fact, they find that. And obviously with sentencing guidelines, that could be decreased. But they could, if they think that they have enough evidence, and at any point, they could raise that charge.
All right, thanks, Terry. Coming up on Law and Crime Daily, the final witness is called in the Derek Chauvin trial as we await closing arguments. Plus, the decades-old investigation into a missing college student gets new leads. The location where police now believe KRISTIN Smart was murdered. That's next. The father and son charged with the murder and alleged cover-up of a California college student in 1996 appeared in court for the first time. Cal Poly State University student KRISTIN Smart seemingly vanished 24 years ago after leaving a party. Her ex-classmate, Paul Flores, is now accused of killing her. Investigators recently searched his phone and the homes of his family members. They say new evidence links Flores to Smart's murder, but her body has not yet been found. And now, prosecutors are saying Flores killed Smart while he was attempting to rape her.
The statute of limitations on a rape charge from 1996 has already expired, considering the fact that KRISTIN was an adult over 18. So we do not anticipate filing charges for a specific rape. But the allegation that he was committing or attempting to commit a rape while when he killed her is the basis for which we are able to file first-degree felony murder charges. We do have evidence in this case that leads us to conclude that there very well may be additional victims in the Southern California area, and I don't want to go into the nature of of that, but he was known to frequent bars in the San Pedro area and in Los Angeles County.
So, Brian, they say they're looking for more evidence of other crimes Paul Flores may have committed. But if they haven't found the body of KRISTIN Smart, how can they know he tried to rape her?
Yeah, Brian Ross, I have seen homicide cases without a body. I have never seen a rape case without a body. I don't know how they're going to be able to prove that. I don't know who's going to be able to testify to that. And I think there's also a legal hurdle as well. And the question becomes, as you can kind of heard that the prosecutor saying there, if you can't charge the person for rape because of statute of limitations, how are you going to use that as a launching point to charge someone for a higher crime? I would expect a lot of motions in this regard and probably a potential appellate issue here as well if they can't prove the fundamental building blocks to lead themselves up to that charge. This is going to be an interesting case. Definitely got to keep our eyes on it.
Indeed, and Terry, this is a very cold case with no body. How do they make that case to a jury?
It's going to be very difficult, Brian. If you think about it, when you have a body, that does help the investigation. You can understand that someone died from a knife attack and you look for the knife, or whether there was a gunshot or a blunt trauma. When you don't have a body, you don't have those types of clues, so it makes it much more difficult. So what the prosecution is going to need to do is rely on the circumstantial evidence, like perhaps there's some DNA there, or perhaps the electronic information that is available to the prosecution and to the authorities. So they're going to also look at testimony from other individuals, witnesses who might have seen her before she disappeared. It will be harder, but it is possible, Brian.
All right, thanks, Terry. When we come back into the courtroom for the Derek Chauvin trial, the defense's controversial expert witness testimony. You don't want to miss this. Back now to Minneapolis, where Derek Chauvin's attorney called his own forensic pathologist to talk about George Floyd's cause of death. On cross-examination, prosecutors went after the expert's assessment that carbon monoxide from the police vehicle was a contributing factor.
Do you agree that you shouldn't come at this in a way that's biased? You agree with that, don't you?
Absolutely agree with that, yes.
You shouldn't cherry pick facts.
No.
You shouldn't try to confuse the jury.
Correct.
You haven't seen any data or test results that showed Mr. Floyd had a single injury from carbon monoxide. Is that true?
That is correct, because it was never sent to the laboratory for that test.
I asked you whether it was true, sir. Yes or no?
It is true.
Do you agree with me that there was no finding of carbon monoxide poisoning from Dr. Baker's autopsy review?
I do.
And remember, this expert says George Floyd died from cardiac arrhythmia, not from Derek Chauvin's knee, a point the defense made sure to get across on what's called the redirect.
Based upon your review of the video in this case, did you observe Mr. Chauvin's knee obstructing the carotid artery of Mr. Floyd?
That knee did not obstruct either carotid artery. And even if it had obstructed one, the carotid artery on the other side, plus the two vertebral arteries, would continue to supply the brain with enough blood for it to function.
I'm not gonna run, man. Right. I know I can't breathe. I can't breathe.
You're talking and you can't breathe. Oxygen to can't breathe.
I just had COVID, man. I can't breathe. Okay.
Did it appear to you that Mr. Chauvin had a tight, firm grip around Mr. Floyd's neck?
No, actually it looked very loose, and the hand was actually gripping the back of the neck in this sort of spinal column area with a considerable gap in the front.
So with closing arguments set for next week, the lawyers now have a long weekend to get ready for their closing arguments. Brian, what are the main points you would make if you're doing the state's arguments?
The main points I'd be looking at for the state's argument would come from Chief Arredondo, Dr. Tobin, and then Philonise Floyd, because that's really where you're getting a lot of the use of force, the medical information, and as well as the emotional impact. When we think about persuasion, I know it's a bit of a history lesson, Aristotle actually talked just about that, the credibility, the logic, and the empathy or the emotion to help persuade people. And I think the prosecution had a lot more of those three elements than the defense did.
And Terri, if you're on the defense side, what are the main points they have to make?
Well, I think the defense has a much more difficult case. Hopefully, they have been preparing from day one, because to have a great closing, you need to make sure you're taking notes. Their two main issues are the use of force and the cause of death. I think their strongest witness for the use of force was Barry Broad, although he was not very good under cross-examination. But he came to the conclusion, and the jury is going to have to determine whether or not they believe him, but he came to the conclusion that Chauvin was justified and that he was following police procedures. And so if that's the case, the jury is going to listen to that, and it's up to them to believe whether or not he was credible. Then, you know, they also showed Peter Chang, and he is the officer who came to the scene and said that the crowd was distracting. And to a certain extent, I think that the defense is going to have to focus on that. We've already talked about the cause of the death, and clearly Fowler was the #1 witness for the cause of death. And I think we're going to have to look at whether or not the jury is going to believe Fowler. And I think the defense is going to look and determine whether or not Fowler's testimony that everything contributed, and it wasn't the knee on the neck, the knee on the back, it was all of these other issues like his heart, like anxiety, even carbon monoxide. And so I think that's what the defense is going to have to focus upon.
And Brian, very quickly, what's the mixture here of emotion and facts as you make the closing arguments?
So I think in closing arguments, we're going to be expecting a lot of the arguments that we've heard so far. Prosecution is going to try to cover up all of those reasonable doubt holes that the defense is trying to poke through. I don't know if it's going to really work for the defense. Don't forget, the prosecution gets to go last in that summation.
All right, Brian and Terri, thank you so much. Thank you all for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.